Hello, my name is Kevin McElroy, and I'm here to provide you with a thumbnail sketch of conflicts of law, the subject conflicts of law, and how it's presented generally on the Uniform Bar exam, and hopefully to help you prepare for that exam on this particular subject. Doing this through the auspices of the good people of academic support. We work very hard to help you all and to help you all pass the bar, which we all have faith in you and your ability to do. But anyway, without further ado, let's get into conflicts of law. I just so happen to have a PowerPoint on that very subject. Okay. All right. So there we go. First of all, how is it tested on the bar exam? It is not a subject that shows up every year. Okay. But it has been tested something like 3 of the last 10 years. So it does pop up. It does not, you won't run into a conflicts of law. Well, in the past, no one has run into a conflicts of law exam question. What it usually is a secondary topic, usually in Civ Pro questions. So you might have a question about whether it's jurisdiction, along those lines, whether or not service was proper, whatever type of civil procedure question they may want to give. And then afterwards, so you'll have a fact pattern in 3 or 4 prompts. There may be 1 or 2 questions on conflicts of law. Okay. And all right, now it also pops up under family law questions and occasionally under questions with trust and estates and wills. All right. So as I said in about 3 of the last 10 years, but harder stats coming out of the academic support people that in the years 2006 to 2018 was tested 35% of the time. So about 1 out of 3 years, you're going to run into this. Okay. They will often cover issues regarding domicile, whether or not a court has jurisdiction, choice of law, and enforcements once in those years. So as you can see, it's not a heavily tested subject, but it's not all that rare either. Okay, so what we're going to talk about today, briefly, what I'm trying to do is condense a whole semester's course into about half an hour, probably a little more. Anyway, step 1, we're going to break this 2 steps. What is choice of law? How does it work? And then 2, I'm going to give a brief overview of the full faith and credit clause as it of the United States Constitution as it relates to choice of law. And what we're going to find out is that the analysis under choice of law is more extensive than it is where you already have a judgment. So you have a choice of law where you're trying to decide what laws states apply in order to have a case and have potentially a trial. And once, however, there has been a final judgment, the full faith and credit clause of the United States Constitution mandates that, with very, very few exceptions, that every state recognize that final judgment. So we're going to hit on both of those topics. All right. Choice of law, what is it? Okay, well, let's say you have a case and it impacts or is impacted by multiple states. Maybe the parties live in 2 states, maybe events that led to the lawsuit occurred in more than 1 state. Okay. Choice of law or conflicts of law decides what state's substantive law determines the outcome of the case. So every state has its own body of choice of law rules. I'm going to use choice of law and conflict of law and conflicts interchangeably, okay? They're almost always common law. There's not a lot of legislatively passed, executive signed choice of law rules floating around in the 50 states, okay? So that's important. We'll see an instance where that's somewhat determinative of what goes on, all right? So what you do is when a lawsuit's filed, you go to the forums, the place where it's filed, choice of law rules, with very few exceptions, and I'll hit on those. And you look at their choice of law rules. So you file in state A. And again, there's a case where it has contacts with multiple states. The parties from different states, events were happening in different states. And by the way, this is true also when you deal with foreign nations. But I'm going to talk about states because that's the usual context. So let's say you file in state A. You look at state A's choice of law rules. Again, usually common law. And state A's choice of law rules will lead you to which state's substantive laws will be applied. So just because you're in state A doesn't mean, in court in state A, does not mean you're going to apply state A's laws, okay? Also, we'll talk a little bit about that you might apply state A's laws, substantive laws, to some issues, and states B laws to other issues, and possibly state C laws to yet other issues, okay? It's almost kind of like an interstate ERIE, as opposed to federal court versus state court with ERIE, federal law versus state law. It's which state's laws are going to apply. If you're in federal court, due to federal question subject matter jurisdiction, then you're not going to look at any court's choice of law issues, any state's choice of law issues. You're going to just apply federal law to it. If you're in federal court on diversity subject matter jurisdiction or supplemental subject matter jurisdiction, so you're determining state law issues, then you will be applying the choice of law rules of a particular state. And it's usually, and I'll go into this in detail, and this is a very important point, because I've seen it come up on the bar in the last decade. But generally, a federal court sitting in diversity will apply the choice of law rules of the state in which the federal court is located. And we'll get to some exceptions to that, all right? So again, the purpose of the choice of law rules is the first thing you got to understand, is to determine which jurisdictions, which states' substantive law will be applied in a case where there's more than one jurisdiction has an interest or connection to the case. Ta-da, okay? So let's say you file a case in New York and it involves a car accident in Pennsylvania. Well, New York's choice of law rules, I would guess, without even looking, is going to tell you that even though you're in New York State court, you're going to apply the traffic and vehicle rules of Pennsylvania. Were you speeding? Did you make a right on red? Was that okay? Maybe the blood alcohol level for DUI is different in both states. So were you incapacitated in some way? Was your license valid? Was your insurance sufficient? Those things, I think it makes perfect sense to you, can only be determined by the state you were driving in. So if Pennsylvania has a speed limit of 60 and you were going 58, you're fine. But if New York had a speed limit of 50 and you're going 58 in Pennsylvania, what difference does that make? That's the substantive rule. So you use New York's choice of law rules to tell you which state's substantive rules to use, okay? And the car accident is the simplest example. All right. Now, I get to this early before we lose you to a nap. This is very important. This one, if you learn one slide today, learn this one. This is how conflicts in federal court is handled, where the subject matter jurisdiction is based on diversity, okay? Not federal question. So we got to go back in history a little bit. We'll start with something that I'm sure was as painful for you to learn as it was for me, but not as painful for me to learn as it was to try to teach in Civ Pro, okay? In 1938, Erie versus Tompkins. If you haven't heard of it, start studying, all right? Where the federal court held that in federal courts, excuse me, the Supreme Court held that when federal courts are sitting in diversity, they have to rely on state substantive law, including state common law. Prior to that, under Swift versus Tyson, federal courts only had to apply in diversity cases state constitutional law and state statutory law, but not state common law. Erie changed that and said state common law is part of the law. So when you're sitting in diversity federal district courts, you should apply the state law, state substantive law, including common law, case law, okay? And you would apply, of course, federal procedural law, but that's not our issue here. 3 years later, along comes Claxon versus Stentor. While Erie said that generally about common law, Erie didn't mention anything about choice of law. And the court in Claxon held that in diversity cases, the federal courts are required to follow the choice of law rules, usually common law, right? That prevailed in the state in which the federal court sits. So if you sue in federal court in the Southern District of New York, they're going to apply the choice of law rules of the state of New York. Simple, right? Okay, 1964, along comes Van Dusen versus Barrett. Think of it as an exception to Claxon. It's not complicated, makes a ton of sense. When a diversity case is transferred under 28 U.S.C. 1404, which is, you all may recall, something called forum nonconvenience, right? Where a case is transferred for the convenience of the parties and witnesses, basically. And section 1404 is a codification of the common law forum nonconvenience. So when a case is transferred under forum nonconvenience, the transferee court, the court it goes to, must apply the choice of law rules that the transferor court, the court that it was first filed in, would have applied under Claxon. So take our case. Case is filed in New York. It's about an accident in Pennsylvania. Okay. There's no problem with jurisdiction or venue, subject matter, personal jurisdiction. The case is properly in New York. But all the witnesses, all the documents, things like that are located in Pennsylvania, outside the subpoena power of New York State federal court. So the case gets transferred under 28 U.S.C. 1404 to federal court in Pennsylvania. All right. The Claxon says federal court sitting in diversity applies the choice of law rules of the state it sits in. So you would think after the transfer, the court in the Western District of Pennsylvania would apply Pennsylvania's choice of law rules, but this is an exception. You stick with the choice of law rules of the original state where it was filed, in our little scenario, New York. Why? Because that's one of the advantages a plaintiff gets. A plaintiff gets to pick within the limits of personal jurisdiction and venue what state they're going to bring a suit in. And as I said, a forum nonconvenience transfer is not based on anything wrong with the venue that's selected by the plaintiff. There was jurisdiction, there was subject matter jurisdiction, and there was proper venue. It's transferred merely for convenience. So the thought process is the plaintiff should not lose their advantage. They didn't do anything wrong here. And we want the court to transfer for convenience purposes, if that's the proper ruling. And we don't want the court worrying about whether or not the plaintiff's being compromised or prejudiced. Okay? So in our case, it's filed in New York, it's transferred to Pennsylvania under 1404. The Pennsylvania court will now apply the New York choice of law rules to determine which state's substantive laws will be applied. Now, just a quick thing, this falls more into civ pro, but just very quickly, federal courts can only transfer to other federal courts. And we're going to see that come up in a little bit, okay, where that might matter. Matter of fact, we're going to see it right away. The last case in this little quadruple is called Atlantic Marine versus U.S. District Court for the Western District of Texas. Think of this as an exception to Van Dusen. Now, this will only come up in a contracts case, not in a tort case, because where the parties have a valid forum contract clause, in a lot of contracts these days, it'll say right in the contract, if any lawsuit should arise out of this contract, it shall be venued in the Southern District of New York, state court in Maryland, or it might just say Manhattan, New York, in which case you could bring it in state courts, New York Supreme, or if you have diversity jurisdiction or some other type of federal subject matter jurisdiction, you could bring it in the Southern District of New York. So you might have a choice, depending on how it's phrased. So in a contracts case where it says any lawsuit shall be arising out of this contract shall be brought in the county of New York, New York. Well, that's Manhattan. And there are two courts in Manhattan for our purposes. There is Supreme Court of New York, New York County, and there is the Federal District Court for the Southern District of New York. You could bring it in either one, okay? So if you have a case that involves a contract with a choice of forum clause, okay, that says if there's a lawsuit arising out of this, it'll be brought in Pennsylvania. And it's brought in New York. The court can transfer it under 1404, but it could only transfer to the Southern District of New York because a federal court can only transfer to another federal court. It can't transfer to New York State Court, but it could transfer to the Southern District of New York, okay? And it should in that case, under 1404. Because 1404 says that a case can be transferred for forum nonconvenience purposes for any, to any other district in which it could have originally been brought or to which the parties consented. Now, in this type of case, where there is a valid forum selection clause, and the plaintiff just ignores it and files somewhere else, that's what happened here. The parties in Atlantic Marine had a forum selection clause that said any lawsuit will be filed in Virginia. And then plaintiffs went and filed in Texas. Well, the court transferred it under 1404 to federal court in Virginia because they couldn't transfer it to state court in Virginia. And the clause said Virginia, it didn't specify, so they could transfer either one, and there was diversity. But now we're not going to follow Van Dusen and apply the choice of law rules of Texas where the plaintiff filed. We're going to apply the choice of law rules of Virginia, where the contract said it should have been filed, because now the plaintiff did do something wrong. They just ignored a proper choice of forum clause. So we're not going to let them benefit. Okay? You should have been in Virginia in the first place. We're sending you to Virginia. And had you filed in Virginia originally, clearly under Claxton, you would be applying the choice of law rules of Virginia. So that's what we're going to do. Okay? So you can see why Van Dusen and Atlantic Marine come out differently. In Van Dusen, the plaintiff does nothing wrong, so the plaintiff doesn't lose any advantage it might have gotten from the choice of law rules where it filed the case. In Atlantic Marine, the plaintiff was circumventing the party's decision, the party's agreement. All right, which leads us to something maybe I should have talked about already, but when you're a plaintiff and you're getting ready to file a case, and the case has contacts with multiple states, you don't just necessarily file in the state that has the best substantive law for you. You've got to look at the choice of law rules, because let's say Pennsylvania's got the best substantive law for you. So you file in Pennsylvania, and guess what? Pennsylvania's choice of law rules tell you, we're going to, yeah, you'll be in court in Pennsylvania, but we're going to apply New York substantive law. So you have to look at which state's choice of law rules will lead you to the body of substantive laws you want. That's why Van Dusen and Atlantic Marine matter. Presumably the plaintiffs looked into this before they filed. And in Van Dusen, where they did nothing wrong, even though they get transferred, they get to keep their selection of choice of law rules, basically. In Atlantic Marine, where they were circumventing a proper contract clause, they're not going to be allowed to benefit. Okay? All right. There are three major approaches to choice of law rules floating around out there. There's what's called vested rights. It's also known as the traditional approach, and it was embodied in the restatement first of contracts. You remember restatements, they're not really law. They're a bunch of legal academics who got together and said, you know what the law should be for conflicts, for contracts, for torts, whatever. Now, sometimes it becomes law because a legislature or a court adopts it, but until that point, it's not, okay? All right, now, you should know that this first restatement, pardon me, came out in about 1934. It's still out there, but really, it only holds sway in about 10 states. So generally, on the bar exam, you're more likely to see the most significant relationships, or the modern approach, which was embodying the restatement second of conflicts, late 60s, early 70s, because 40 states use that or some sort of system that is much more resembling the second restatement than the first, okay? And there's also this other thing called the government interest test, where we look at which state has the most interest, the most skin in the game of how this thing comes out, how this lawsuit comes out. So they want, that state will want its laws applied, okay? And the note I got here, don't apply unless told about a particular court as the forum. You know, you mostly will assume that it's first or second restatement, unless you're told it's a government interest test. All right, so that doesn't come up a lot. All right, but you're going to have to be told. If you're not told on the bar exam, your best bet is probably to cover the second restatement. If you got some time left, say, but if this state follows the first restatement. But the questions I've seen usually pick one or the other. Okay, so I wouldn't worry about that too much. All right. The first restatement is very simple. The second restatement, as you'll see, is a little more complicated. Not complicated, but it requires more analysis. We'll get into that in a minute. All right, but let's start with the first restatement. All right, also known as the traditional approach. For torts, and I'm just going to cover torts and contracts here. Restatement's also important in family law. Now, what I know about family law, I've already told you. That's right, I haven't said anything about family law. I don't know anything about family law, thank God. Having a wife and 3 kids, it's good I didn't learn anything, okay? So my advice on any family law issues is ask Professor Shepard. But anyway, for torts, the restatement first says, apply the substantive law of the, quote, place of the wrong. And then it defines the place of the wrong is defined as the place where the last event necessary to constitute a cause of action took place. Now, I've racked my little brain, and to me, it seems that in tort, personal injury, or property damage, the last thing that happens, and I'm going to say almost always, but I can't think of a time when it's not always, is the injury, especially in personal injury, right? Somebody drives negligently, somebody digs a hole in their yard right up against the sidewalk and then goes in for the night, leaves this huge hole without putting any yellow tape around it, or a flare or a blinking light or something to protect some people from walking by and falling in the hole. Somebody has a loose banister on their staircase and they know it's loose and they leave it loose for a long time. All that's negligent actions, but until somebody falls and gets hurt, there's no cause of action. The last event that causes the cause of action is, and again, I'll hedge it a little bit, almost always the injury, which is known as the lex loci theory. So you would apply under the first restatement for torts, the place of injury, the law of the place of injury, okay? So you go into court in a state that applies the first restatement. You file there, but you've got jurisdiction there because that's where the defendant lived. But you're the plaintiff. Your injury occurred in another state. You apply the choice of law rules of the state that you filed in. And if they follow the first restatement, your case will stay in that court. Unless there's other grounds to move it. But it'll apply the substantive laws of the place you got hurt. Simple. There's one thing you want to say about the first restatement. It's simple and it's uniform, okay? But without getting into it here, there are times where it's just a mess and it just doesn't make sense. That's why there's a second restatement, all right? Under contracts, you generally apply the substantive law of the place of contracting, all right? And that's under section 311 of the first restatement dealing with contracts. The law of the state regarding, you apply the law of the state, which is the law of the place of contracting. And that determine things like whether there's formation of a contract. Comment D says the law of place of contracting is defined as the, quote, place in which under the laws of contracts, the principal event necessary to make a contract occurs, period. Not the laws of that state, but the laws of the general laws of contracts. Well, we all took contracts. You took them much more recently than I did, but my recollection is usually a contract is made when there's offer and acceptance, but not always. Sometimes it has to be delivery of the contract. Sometimes there has to be some precondition. Maybe somebody has to get insurance before. You may want to hire somebody to take a tree down in your house, but they're not insured and the tree overhangs your neighbor's yard. So you tell them, we have a deal. This is the price. This is the work you're going to do. But you got to go get insurance first. So there's no contract. You have no duty to let them do the work or to pay them until they get the insurance. All right. So you've got to read the fact pattern carefully, right? What is the principal event that is necessary to make a contract? What's got to happen? So that's 311, all right? Now, section 32 of the restatement states that the law of the place of contracting, and that's how most of the first restatement contract sections are written. The law of the place of contracting will determine blah, 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 blah. Okay, so the law of the place of contracting, the law of the primary event and necessary event, all right, determines the validity of the contract with respect to capacity. Is the person you entered into old enough? Are they mentally competent? Do they have enough ownership interest, the right type of ownership interest in something they're selling? Okay. The necessary form, if any, in which the contract, in which the promise is made. Think statute of frauds. The form, does it have to be written? Whose statute of frauds are we using? We're going to use the statute of frauds of the law of the place of contracting. So you go back to 311, figure out what the law of the place of contracting is, then figure out what the statute of frauds in that place is. Okay. Mutual assent. How is acceptance conveyed? Okay. What's proper consideration? Okay. Fraud and illegality. I'm not going to go through each one of these, but you can see them, right? The time when and the place where the promise by its terms are to be performed. So if they're not specific as to where things are being done, but they say things like you have to deliver your payment every month to the defendants, to the plaintiff's main office, as opposed to an actual address. Well, what constitutes a main office? Things like that. All right. So you can see it's layered, but for torts, place of injury, for contract, place of contracting. Once you get over those hurdles, place of injury isn't too hard to figure out usually. Okay. Although you may have a latent injury, and that's a problem. But after that, you're pretty much done. Nice and simple. You should be so lucky that that would be a first restatement question, because you'd be done. Second restatement, and again, this is now in 40 states, or again, some approach much more defined with the second restatement than the first restatement. It's less simple than the first restatement. So the courts have more discretion and you get a wider range of outcomes. And frankly, you get some very bad decisions when you read a lot of decisions. And you get some good ones too. And then there are some where it's very arguable and it could go either way. Okay. Now, this works differently. For both tort and contract cases, you start with section 6, which is called the choice of law principles of the restatement second. And then you go to specific sections beyond that, depending on whether you're in a tort case or contract case. So let's take a look at section 6. And looking at section 6 in this vacuum until we get to the next one is a little hard. I think the next one will put, when we go to this more specific sections, you'll see a little more, meat on the skeleton. It'll help you. Okay. Now, the first thing is very important. 6.1. Keep your eye out for this in a fact pattern if it comes up on the bar exam. A court subject to constitutional restrictions, and I'll talk about that in a little while, will follow a statutory directive of its own state on choice of law. So if you file in Idaho, and Idaho's got a statutory as opposed to a common law, and I told you in the beginning, this would make a difference somewhere, and this is it. If there's a statutory choice of law provision in Idaho law, Idaho courts must enforce it. End of analysis. Well, you use the analysis in the statute. End of restatement second. You don't go to these things here that we're about to go to. But again, most choice of law is court made. So In real life, that's not going to be an issue too often. On a bar exam, which is less related to real life than it should be, okay, this can come up. And one way it could come up is they could give you, well, where under the second restatement, what state substantive law would be applied if the plaintiff filed their action in Pennsylvania? What state substantive law would apply if the plaintiff filed their claim in Georgia, the same claim under the same fact pattern that they give you? Okay. And one of them will be a statutory choice of law. And then you follow that state's statutory choice of law. And the other one will be common law. And you go to this. You start with section 6. When there is no such directive, meaning a statutory directive, the factors relevant to the choice of the applicable rule of law include. These are the things a court should look at to decide which state's substantive law should be applied. And it says include, so they're not trying to be all-encompassing here, all right? But the needs of the interstate and international systems, what in God's name does that mean? Is it going to cause problems if one state's laws are applied versus the other to trade, whether it be international or interstate? Okay, is it going to be a matter of trade is going to be severely hampered, or within states, traffic, movement of people will be severely hampered by one than the other? Well, we want to err on the side that makes it easier for goods and people to move around. The relevant policies of the forum, and then C, the relevant policies of other interested states. So what public policies are there? Take a pre-1995 type America, where the only place you could go to gamble legally was Nevada and then New Jersey. So if this was a case involving a contract to gamble or tort involving gambling, if you were in Nevada, you'd have a much different public policy on legalized gambling than you would if you were in Utah. And I imagine you still would, okay? So you look at the public policies of both states. Does one state have a firm, very important public policy, and another state not really, either way? So, it's an issue that one of the states hasn't really said, well, our stance on this is this or this. They just sort of shrug their shoulders and don't have a very strong stance as indicated by their constitution, by their statutory laws, or even by their common law to a certain extent. Okay? So you would compare that. All right. The protection of justified expectations. Now, remember I told you start with 6, and then you go to the sections that have to do with either tort or contract. Well, there usually isn't a lot of expectations in tort. When I'm walking down the street, I'm not expecting to get mugged. When I get in my car, I don't expect to have a car accident. When I enter into a contract, I have certain expectations of how the parties are going to act. Okay? So that's a much more important factor in contracts. Matter of fact, it's almost meaningless in tort, all right? The basic policies underlying the particular field of law. What are general contract rules, sort of majority rules that people would expect to be followed, unless states, again, have taken steps to say, well, that might be what people normally do, but that's not what we do in this state, all right? Which leads into predictability and uniformity of result. Those are good things. These are all things you want to err on the side of when choosing which state's laws to apply. And ease and determination application of law to be applied. This one's a little tough because no court's ever going to say, well, we have to apply our own law because we just don't understand what they're doing in South Carolina. No judge is really going to admit that. But ease and determination and application of the law to be applied, every judge in every state and every lawyer who practices primarily in one state is more at home with the laws of their state. So this is always, to the extent it does anything, it's going to lead to an application of the forum state substantive laws, because it'd be easier for everybody. All right. If you're in a tort case, you look at section 6, and then you look at section 145 for tort only, right? Which it tells you in the beginning, under number 1, to help you figure out which state has the most significant relationship to the occurrence and the parties under the principles of 6. So 6 is like this big umbrella thing. 145 is the particulars for a tort, because what we're trying to figure out is which state's substantive law are we going to use. The states that have the most significant relationship to the occurrence, that's the one we're going to use. Okay, and these are the things we look at. We look at 6, but we also look at 145 2A. Contacts to be taken into account in applying the principles of 6 to determine the law applicable to an issue include. So they go hand in hand. Okay. The place where the injury occurred. Aha. Lex loci. Restatement first. Still, probably in tort, the single most important issue of all these factors. They give you all these factors, but nowhere does it say how significant each factor is. Is the place of the injury more significant factor than, say, number 2, the place where the conduct causing the injury occurred? They don't tell you, so it's up to the judge. So there's a lot of discretion, and you can use that in essays. You can say, well, assuming the court were to find the place where the injury occurred to be the most significant, because there's some here on this side, there's some saying apply the rules of substantive law of state A, and some saying apply the substantive laws of state B. So it's a close call, which is a bar exam. But the most significant relationships, because that's what it's about. It's not the number, it's the most significant. Although if you got them all, or almost all of them, you're in good shape. But nowhere do they rank the significance. That's why the courts have a lot more discretion here. And that's why it's not as simple and as uniform as the first restate. So the place where the injury occurred. Okay, so I go online and I buy something online that's made in, I don't know, Alabama, and they ship it to my house in New York, and I open the package and I plug it in, whatever the heck it is, and it blows up. I've been injured in New York. The place where the conduct causing the injury occurred, B. Well, it was negligently manufactured in Alabama. So it's not the same place all the time. Now, in a car accident, it'd be the same place. In somebody falling down a flight of stairs, it'd be the same place. All right. The domicile, residence, nationality, place of incorporation, and place of business of the parties. Well, what states have interest? For starters, place where people get hurt or there's property damage, but also where people live. As a citizen of New York, whenever I get hurt, wherever I get hurt, New York has some interest in it. Because if I can't work anymore, and if I'm the sole breadwinner of my family, well, guess what? We're going on public assistance. And guess who's paying it for it? The good people, the state of New York. So New York has an interest. It might not be enough of an interest to apply New York law, but New York has an interest because they want me to win a big judgment and collect a lot of money so they don't have to send me a check every month. Okay? The place of the relationship, if any, between the parties is centered. Now, this one's tough, okay? If you have a car accident with somebody who you've never met before, the place of your relationship, if you want to call it that, is where your cars hit each other. It's the only relationship you have. So, see a lot of fact patterns will lead you back to the place of injury, because there you would have the place of injury is where the car accident is. The place where the conduct causing injury, the negligent driving, is where the car accident is. The place of the relationship between the parties is centered in that, where that is, okay? And probably, usually, maybe one of the two parties is from that state. But you've got to add them all up, and generally that's not what's on the bar exam. It's going to be kind of a strict product liability type thing usually, all right, where something is made somewhere and shipped somewhere else and maybe used in a third place. Okay, you manufacture in Oregon, brake fluid, and you send it to me in New York. I buy it in a store in New York. I put it in my car, and I'm driving along in Delaware, and my brakes fail because your brake fluid's no good. There you go. We got a place to manufacture from a corporation that may or may not be a domicile of Oregon. It might be that might be where its factory is, but not its principal place of business, or not where it was incorporated. Okay. The other driver, God knows where they're from. Okay. The place of injury is in Delaware. the place where the conduct causing injury, the negligent manufacture of brake fluid, is in Oregon. The other party lives in Delaware. I live in New York. So factors are all over the place. So it's not just numbers, it's what's most significant. And we'll get to this in a second. You're going to see in tort cases, the place of injury is still a major, if not the most important factor. And I've combined 146 and 175 here because they're the same wording with a different sort of introduction. All right. So if we look at 146, in an action for personal injuries under the second restatement, an action for personal injury, the local laws of the state where the injury occurred determines the rights and liabilities of the parties. Unless, with respect to a particular issue, some other state has a more significant relationship under the principles stated in section 6, in which event the local law of that state will be applied. Okay, so this tells us two things. One, there's like a presumption that's the place of injury in a personal injury. And in wrongful death, it's the place of injury even if you die somewhere else. If I get injured in a car accident in Delaware and I'm eventually taken home to New York, but I die of my injuries from the car accident, well, it's not where I died, it's where I was injured, all right? So you've got to overcome that. You've got to have, the other states have to have a bigger interest in what's going on under section 6 and section 145, all right? Otherwise, we're going with the injury. So this is the one place where they kind of tell you, hey, you know what the most significant factor is? They don't say it that way, but if you read it, that's clearly what they're saying. All right. The other thing this brings up, and it's not the only place in the restatements, that you can choose, or that the choice of law rules can lead to the application of state A's rules for certain substantive issues and state B's laws for other substantive issues. For instance, there was a case in California where everybody involved in a car accident was Mexican. The car accident happened in California. Both Mexico and California had wrongful death statutes. This is back in the 70s, I think. So wrongful death is a statutory animal. So not every place had it, but they both did. Okay. So you didn't have a conflict there that the decedent's estate could bring a cause of action. That wasn't the problem. In Mexico, the Mexican wrongful death action said who would get the proceeds. That's what wrongful death claims. They're statutory, and they say where the money goes to the extent there's a judgment or a settlement. In Mexico also, they limited the damages that could be obtained to, at the time, something just under $2,000. This is for, a relative who's dead due to the negligence usually of somebody else. California had no cap. What the court determined was they would apply the Mexican wrongful death claim as to the fact that wrongful death was proper, a proper cause of action, and who would get the money. But they would apply the California claim, the California substantive law that did not place a cap. So these people from Mexico could get whatever the jury would award. And what the court determined was that the reason for the cap under Mexican law was to protect Mexican defendants and probably Mexican insurance companies. But since the insurance companies that were involved here, strangely, and the defendants were American, the Mexicans had no interest in protecting them. The Mexico government had no interest in protecting Americans from paying a high price, right? What they were trying to do was protect their own people, usually in the context of a car accident in Mexico, which would, be among Mexicans. But here that wasn't the case. And since California defendants and California insurance does business in a place with no cap, they had to expect that that would be the outcome of most lawsuits they'd be involved in. So that's an example of where the court used Mexican law for some of the issues, who would get the money, California law for other issues, no cap, and certainly for who was negligent based on the driving rules in California. Okay? So again, first section 6 for torts, then to 145. And I just wanted to show you this because when all else fails on a bar exam, remember the place of injury is going to be most likely the correct answer, just like it would be under the first restatement. But unlike a first restatement question, that's the beginning and end of your answer. Here you got to get into it deeper and show no other, with respect to whatever issue or issues they're asking about, the place of injury, the substantive law of the place of injury will be applied unless another jurisdiction has a greater interest in that particular issue. And that shows you how different issues can be resolved under different jurisdictions, substantive laws within the same lawsuit. And that's called découpage, which I'll get to in a little while. There's 2 French words you have to learn here, okay? Now we moved on to contract cases, and this is a bit of a dilly, so I'll do the best I can in the short time I got here. You again start with section 6. Now there are 2 sections you might go to, right? You'll then apply along with section 6, section 187 of the restatement second, if the contract had a choice of law rules. We talked about choice of forum before with Atlantic Marine, where you can pick, if there's a lawsuit, this is where it'll be, okay? Choice of law rules is if we have a lawsuit coming out of this contract, the laws of the state of New York will apply. Okay? And it was Atlantic Marine, by the way, which is the case that basically before Atlantic Marine, courts didn't like choice of law rules, choice of forum rules. And Atlantic Marine, the Supreme Court said, hey, why not? The parties agreed. What's the problem here? Okay. Now, so the first restatement was pre-Atlantic Marine. So the people who wrote this were sort of out ahead of things, right? So again, this is a contract case where there's a choice of law rules. The law of the state chosen by the parties to govern their contractual rights and duties will be applied if the particular issue is one which the parties could have resolved by an explicit provision in their agreement directed to that issue. Get to that in a minute. Or two, the law of the state chosen by the parties to govern the contractor rights and duties will be applied even if a particular issue is one which the parties could not have resolved by an explicit provision in their agreement directed to that issue, unless either the chosen state has no substantial relationship to the parties or transaction, or application of the law of the chosen state would be contrary to a fundamental policy of a state which has a materially greater interest. What does all that mean? All right. Here's the best explanation I can give you, and I can give it to you out of my conflicts book. All right. All right. Under 1, the law of the state chosen by the parties to govern their contractual rights and duties will be applied if the particular issue is one in which the parties could have resolved by an explicit provision. As this book explains better than I could without it, these are issues which the parties would have freedom in a contract to explicitly set forth in the contract how things are going to work. All right. There are rules of contracting in every state that if a contract is silent to something, then this happens. But the parties are free to lay it out and not go to the default. All right. Say there was a rule if basically where contract is silent, any monetary payments to be made shall be made in US dollars. Fair enough. But if the parties want to, they could say it has to be paid in euros. It has to be paid in rubles. Okay? That's number 1. So by saying, okay, if there's a lawsuit and we're wherever we are, we're going to apply and the contract says apply the laws of the state of New York. And the state of New York says any monetary payments has to be in dollars. Then that is read into the contract because the parties could simply have stated that. But the way they stated it was by saying we're using New York law. Okay? Now, New York law, the use of New York law will go to other things too, but that's one of the things it could go to. Now, we go to 2. What if there's something they can't contract around? All right? Mandatory rules, which even if you were writing a contract and you said, both parties agree we don't like the mandatory rule, and the state would say, too bad. That's the law. All right? So just drafting around it wouldn't allow you to get around it. All right? For instance, that when you sue in contract, or when you sue a municipality, a lot of states have this rule. You can't get punitive damages because who pays punitive damage? The taxpayers. So what's the point? And in a contract, we put, well, although the law is that in this state is that you can't sue municipalities for punitive damages, the parties agree in this case you can. If you wrote that into a contract and the laws of the state that doesn't allow you to sue municipalities for punitive damages was applied, that phrase in the contract wouldn't be enforced. You can't write around it. It's a mandatory thing. Here you can. If you say we're going to apply the laws of state A, and state A allows punitive damages against municipalities under these circumstances, 2 will allow it unless, so now it becomes sort of the presumption, unless one of 2 things. The chosen state has no substantial relationship to the parties or transactions. So if we live, work, and everything we're doing is between parties and commerce between Tennessee and Kentucky, and we just decide to apply the laws of the state of Washington, they're not going to allow that to get around these mandatory rules. Okay? Or, just to be one or the other, the application of the law of the chosen state would be contrary to a fundamental policy of a state which has a materially greater interest than the chosen state. So where everything's happening in Kentucky and Tennessee, well, they both have a materially greater interest than the state of Washington, where nothing's happening, nobody's from, the commerce doesn't pass through, payments aren't made to or from. But if it's a close call, say it was between Kentucky and Tennessee, where the parties reside in different states, where one is manufacturing and shipping to Tennessee and the other is sending payment from Tennessee to Kentucky. You have to figure out which has a greater interest to determine whose laws apply. If there was no contractual provision. But if the contractual provision says Tennessee, and it's a close call, they're going to let you walk around any mandatory rules of Kentucky, because Kentucky doesn't have a materially greater interest. Okay? It's not that simple. I get it. Take it apart. Might have to play this a couple of times. Maybe I didn't explain it the best way I possibly could have. But that's the way that works. Okay. Now, what if you have a contract with no choice of law clause? All right. So what do? This looks a lot like what we do in torts. This is section 188. Where in torts, we went to section, what was it, 146 or something. Okay. Along with section 6, you look at the place of contracting, which is like torts, the place of injury. The place of negotiation of the contract, which like torts is the place where the acts or omissions that caused the injury occurred. Okay. The place of performance, the location of the subject matter of the contract. If you're buying, selling a chattel, well, where is it located? That's something we're going to look at. All right. And the domicile, residence, nationality, the place of incorporation of the parties. Now, this isn't as simple as it used to be, okay, because now contracts aren't negotiated where people sit down around a conference table and hash everything out. It's done by phone. It's done by email. It's done by mail. It's done by FedEx. It's done by, well, it's probably not done by fax much anymore with emails. It's done in meetings. So negotiations can happen in many places simultaneously. I can negotiate on the phone from New York with somebody in Maine. Well, where do the negotiations take place? Oh, Maine and New York, I would venture. Okay. Where is the contracting when we reach a deal over the phone, I type it up, I sign it, I send it to you. Where's the contracting? You're in Maine, you sign it there. There's an argument, it's in Maine, because until both parties sign, there's no contract. All right. But again, this goes along with section 6. And these make perfect sense. Right. And section 6, remember, had things about expectations, which I told you in torts doesn't mean anything. Well, in contract, it means a lot because you have expectations. The international and interstate system, contract, right? Goods being shipped, for instance. All right. So that's the big overview of the two major approaches. All right. Now, a couple quick things that you got to be on the lookout for. Due process, constitutional due process. The Supreme Court and other courts have refused to apply the choice of law rules of a court if it results in the application of the substantive law of a state or another jurisdiction. There's nothing to do with the case. There was a case going way back, and all of these really apply to both the first and second restatement. There was a case where a guy owned a boat. Guy lived in Texas. He owned a boat in which was used in Mexico, docked in Mexico. Okay, used in Mexico. Boat had never been to New York. Excuse me, Texas. It was insured by a company in one state who then laid off some of the risk with a New York company. The negotiations for insurance was made wholly outside. Nothing happened in Texas except one party lived there. And under Texas choice of law rules, they applied Texas law. And eventually got to the Supreme Court and they said, nope, due process. None of these other parties would ever think for a minute that Texas law would have anything to do with their contract. Okay, the boat blows up, it's an insurance issue. Probably should have thrown that in, sorry. Okay, so that's the due process. There's got to be some relationship. Now, this is not, again, where a contract says we're going to apply the laws of Australia just because we like the accent, okay? Because there the parties got together and agreed. All right. I talked about this already, the contract choice of law forum clauses. Courts now will apply these. You saw the exceptions under the restatement second. As long as, what the courts finally woke up and said was, wait a minute. Well, I think what they were saying was, why do we care? If you want to be in one state, not the other, great. Who cares? If you want the law of one state, not the other, that's your deal, right? You could have retyped, instead of saying the laws of the state of New York, you could have retyped every law of the state of New York, both common and statutory. Well, that would be a kind of an unwieldy contract. This is just a short-hand way of doing it. So, eventually they came around. And this also goes to, by the way, arbitration, where you have a contract, say if there's any problem with the contract, we're going to the, instead of going to court, we arbitrate. And the Federal Arbitration Act gave a lot of teeth to that. The courts used to try to ignore that, but now they don't, okay? And again, the courts finally woke up and said, hey, less work for us. Now, cases regarding title to real estate will, almost without exception, and again, pretty much without exception, but one never knows, you're going to apply the laws of the state where the real estate is located to determine who owns the state, who owns the real property, okay? As opposed to a chattel, which is not necessarily where it is at the time. That's a factor, but it's not the deciding factor. In fact, a lot of cases say there's no jurisdiction or courts refuse jurisdiction in a state that's not in the same state where the real property is located. And they'll dismiss with instruction to go file in that state because you have at least REM jurisdiction, if nothing else, in that state. And while Schaefer destroyed pretty much quasi in REM's still out there. So you can overcome a choice of law provision that talks about title to property, which doesn't exclude from that real property. This is something you'd have to bring up in an answer to a bar exam question. Well, being that it's real estate located in Nebraska, Nebraska law should apply, if not actually be tried in Nebraska. Now, you gotta be careful with this, okay? Because it has to be about an interest in real estate. But, what is, clearly title, who owns it is one thing. If somebody rents it, well, that's an interest in real estate, especially a short-term lease. It's also just a contract issue. So that is something I would bring up in an exam if it was about renting a summer home, but acknowledging that it doesn't go to ownership. So it's a little bit different. It's not as strong, okay? Now, I didn't know what else to call this other than the two French words. I called them more advanced concepts. There's two things you have to know, and I've already covered one of them. Dépackage, which in French means butchering. That the laws of one state can apply to some of the issues in a case, while the laws of another state apply to other issues in the exact same case. It's what states have an interest in the different issues. See how that's not really going to come up much in the restatement first, because it's not about interest, it's about where the injury occurred. All right. The other thing is called renvoi. And I've got a niece who married a French guy, is fluent in French, and I checked, and that's how you pronounce it, because God knows I wouldn't go my mind French. It's basically a never-ending circle. And here's the important thing to know about this, okay? When you read the choice of law rules of New York or any other state, and it says under New York law, we would apply the laws of Indiana. That means you apply the Indiana substantive laws. You don't go to Indiana's choice of law rules. Because if you want the Indiana's choice of law rules, and what if they said, well, under our choice of law rules, we'd apply New York law? You'd have a never-ending circle, see? So when you start in a state or a nation, and you look at that state's choice of law rules, and that state's choice of law rules says for this issue or for this entire case, we are going to apply the substantive, we're going to apply the laws of another state. They mean the substantive laws. You don't even look at the other state's choice of law rules. That's how you avoid a renvoi. Simple, good little French buzzword to throw in to your bar exam. Okay, so that's the overview on how conflicts works. Quickly, full faith and credit. I promise this is shorter than the rest of it. What do you need? Well, you need a judgment. The full faith and credit clause of the United States Constitution says that, and I'm obviously paraphrasing here, okay? James Madison, I'm not. It says that each state will give full faith and credit to the laws, rules, regulations, judgments of the other states. In conflicts, this is more about judgments than anything, all right? So you have a judgment. Well, there has to have been jurisdiction in the first case in which it was filed. Look, let me back up a second, give you some context. You sue me in Ohio. You win. Congratulations, you got an Ohio judgment. Guess how much my assets in Ohio total? 0. So you could take your Ohio judgment and hang it on the wall because that's all it's good for. So what do? You take your final judgment from Ohio, whether it's federal or state court, doesn't matter. You go to New York and you institute a very simple cause of action that converts the Ohio judgment to a New York judgment. And now with your New York judgment, my vast riches are open for your seizing and freezing. You can freeze my bank accounts. You can seize certain properties and sell it off. You can make my life miserable. If you took your Ohio judgment to my bank in New York or to a sheriff in New York and asked to freeze accounts and seize property, they'd laugh at you. Not only because we're from New York and we look down on everybody else, but it doesn't work. It doesn't work outside the jurisdictions. You have to convert it to a New York, okay? And that's how full faith and credit kicks in. The New York courts will acknowledge the Ohio judgment and issue a New York judgment for the same amount of money, less anything you might have already collected. Okay. But before they do that, or they won't do that if there wasn't proper jurisdiction in the Ohio court, both personal and subject matter jurisdiction of me. Okay. There has to be judgment on the merits. Now that includes summary judgment, it includes default judgments by me. Okay. Now, here's a little wrinkle in this before we go any further. It's maybe more civ pro, but I'm not sure where it falls, so let's just do it. You sue me in Ohio. I've got a choice to make. I can either come to Ohio and defend myself, in which case, if I do and I lose and you have a judgment, then you've got a clear shot at coming to New York and converting it to a New York judgment. Or I can sit back and let you get a default judgment against me. Now, when you come to New York to convert, I can then say there was no personal jurisdiction of me in Ohio. So the Ohio judgment is invalid. And I'm going to have to prove it. The way they served me was improper. I never got served, whatever it might be. Okay. I have no contacts with Ohio. It didn't happen in Ohio. They didn't serve me in Ohio. Due process, you remember all that stuff, international shoe and all that good stuff. No personal jurisdiction of me in Ohio. Therefore, it's an invalid judgment. That sounds great. Here's the problem. If I wait till you come to New York and challenge the Ohio judgment on the basis of lack of jurisdiction, if I lose that argument in New York, I don't get to argue the merits of the case because I defaulted in Ohio. I put all my eggs in the jurisdiction basket. Now, I could also go to Ohio and fight jurisdiction there, but if I lose the jurisdiction question and then I lose the case, when you come to New York, I can't fight the jurisdiction issue. I get one shot at the jurisdiction issue. I got to pick where to fight it. If I fight in Ohio, maybe I'm afraid the Ohio court with an Ohio plaintiff is going to want to find jurisdiction. So I wait for New York. Problem is, if I fight it in New York and lose, I can't then fight the merits of the case. I'm just not liable. Even if you have jurisdiction of me, I'm not liable. If I fight it in Ohio, I can fight both. Okay? So there has to be jurisdiction. There has to be judgment on the merits. There has to be a final judgment. Case has to be over. There has to be nothing left to decide. And that's how we lead into this enforcement of judgments. And the court and under the full faith and credit clause, as long as there was proper jurisdiction, or I waived it, okay, and a final judgment on the merits, when you bring that Ohio judgment to New York, the New York courts will convert it to a New York judgment. That's full faith and credit, okay? It also gives you res judicata, which I'm definitely leaving for civ pro, and collateral estoppel. You remember those great things, right? There are special rules now for family law by statute. Professor Shepard, your boy, okay? All right. This used to come earlier, and then we moved on to choice law. I got to do better editing on the slides. There's one other thing you need to know on this too. I think at least one. In the United States Constitution, there's also this concept of comity, C-O-M-I-T-Y. It is basically full faith and credit, but for foreign countries, not between states, but between a state and a foreign country. The difference is, if you meet those requirements for full faith and credit, it is mandatory. The second state's court has to recognize the judgment of the first state court. And it goes not only to judgments again, but to res judicata. Look, you already sued and lost in the other place, in Ohio. You can't sue me now in New York. And the same with collateral estoppel. That issue was decided in the lawsuit in Ohio. You can't sue me in New York and try to fight that issue again. All right. With comity, it's discretionary. And frankly, countries that we are on good terms with and have a good history with, and a history of, or a similar jurisprudence with, are going to be, it is much more likely that a court in New York or any other state will accept a judgment from there. So the United Kingdom, our jurisprudence grew out of English jurisprudence, which also leads to Canada, Australia, South Africa, English-speaking countries, not because they speak English, but because of this jurisprudential history, okay? Same system. But then you've got France, which is a civil code. But these Western European countries, certainly, we have respect for their court system, and we feel like they give an American defendant a fair day in court. As long as you got a chance, you got your hearing, there was jurisdiction of you, and you were allowed to fight the case if you wanted to. Under comity, it's much more likely that a judgment from those countries is going to be recognized and enforced, as opposed to North Korea right now, Iran, China to a certain extent, although with the Chinese economy being what it is, business transactions under Chinese law may be recognized. Cuba, we're probably not going to want to see too many judgments from Cuba get enforced. So you get the idea. It's some of it's politics, but there are legal reasonings behind it. Okay. All right. Quick review. I promise it'll be quick, and we'll be out of here. Okay. How many approaches are there to choice of law? Well, two main ones, sort of a third one. First restatement, place of wrong, which is place of injury, pretty much. Place of contracting. Second restatement, more complex. What interest, which jurisdiction has the greatest, the most significant relationship to the parties and the actions that led to the lawsuit? That's going to result in the application of the substantive law there. And then there's a government interest test, which is not as commonly covered. Okay. Quickly, let me just give you a quick hypo and my thoughts on it. A tort case, the negligent act and the injury took place in New Jersey, is filed in the Southern District of New York based on diversity jurisdiction. Assume jurisdiction is proper, okay? The plaintiff was served while in New York, defendant was served while in New York, but lives in Connecticut. The plaintiff lives in Pennsylvania. Which state's choice of law rules should the judge apply? This is the easy one. It's diversity in New York, Southern District of New York. Claxon says, federal court sitting in diversity will apply the law of the state in which it sits. Okay? The case is filed in New York. We apply New York's choice of law rules. Doesn't mean we apply New York's law, substantive law, but New York's choice of law rules. Which state's substantive laws should be filed in the case under the restatement first? Place of wrong, place of injury. The person was injured in New Jersey. See? First restatement, simple. Sorry, second restatement. What do we got to look at? We got to look at all those factors under Section 6 and Section, I think it's 145. Okay. Well, putting them together, we would do Section 6 first. That's the right way to do it, but I'm just going to kind of do them together here. Okay. We know that where the injury took place and where the negligent act took place were both in New Jersey. And then if you remember, I think it was Section 146 said that that's the place where the injury takes place is the law we're going to apply unless another state has greater interest on that issue. So here, given those two things, the place of injury and place of the wrong that led to the injury, it's going to be New Jersey between us. Spoiler alert, okay? The plaintiff was served in New York, so what? Defendant. Plaintiff was served, So defendant lives in Connecticut, but she works in New York, so they tag him when they get off the train in New York. Remember trains, people commuting pre-pandemic? Okay. New York has no interest in this. The people live in Connecticut and Pennsylvania, the injuries in New Jersey. New York law is not going to apply. New York has no skin in this game at all. Okay. Defendant lives in Connecticut. All right, Connecticut's got some interest in protecting its people, but it's New Jersey. I mean, this isn't North Korea we're talking. And the plaintiff lives in Pennsylvania. Pennsylvania's got some interest in making sure the plaintiff is compensated. But under the rules that we looked at under the second restatement, so while Pennsylvania has a relationship, has contact, has an interest, and Connecticut has one, New Jersey's got a lot more. Okay, so New Jersey be first choice here. Pennsylvania probably second choice. Connecticut third. New York just happens to be where somebody got served and where the plaintiff's lawyer probably lives and practices. All right. So obviously on a bar exam, you'd go through this in a little more detail, but that's the way it's done. Okay. So look, they came out the same in this fact pattern. First restatement, second restatement. All right. That happens sometime, but the analysis is much different because I went through this very shorthandedly. You'd have to go look at all the factors in number 6, section 6, and section 145. All right. Well, I hope that's helpful. If you have any questions after seeing this, that's my email. You can send it to me. I'll reply. Don't send it to me the day before the bar at night because I'll be asleep on the couch. But otherwise, if you have any questions, good luck. You can do this. Don't worry about it. All right. So congratulations on your imminent and what I'm going to assume is inevitable graduation, and good luck on the bar. If I can be any help, you've got my email now. Take care.